This is State versus Williamson. I can already ascertain that we can hear both attorneys, and you can hear us fine. We can see you. All right. I just want to go over the ground rules again. You each will have 15 minutes. The appellant, which is the state here, can reserve up to 5 minutes if they so desire. And I remind everybody, since we are telecasting this, that we're live streaming it as well as recording it. We do not use the names of victims or the names of any minors, please. All right, are we ready to proceed?
Yes, Your Honor.
And I apologize for us running late. We had technology issues with the other case. So, okay. All right. And for the state, you want to save any time?
I would like to reserve 5 minutes.
Thank you.
May it please the court, I'm Heaven DiMartino here on behalf of the state of Ohio. We are the appellant in this matter. We are asking that this court reverse the trial court's order granting Antonio Williamson's motion to dismiss counts 6 through 15 of the indictment, which related to selective prosecution. With regard to just the backdrop of how these charges occurred, it's relevant to the analysis of the two-pronged test for selective prosecution. In this case, the Department of Homeland Security received information regarding a sexual assault allegedly involving a former Summit County Sheriff's Deputy, Antonio Williamson. They asked the Akron Police Department to look into these charges. The Akron Police Department contacted Summit County Sheriff Deputy Klein, who was their liaison, and he then asked, he was asked to look into whether Mr. Williamson had done any OLEG searches in relation to this sexual assault allegation. So since the Attorney General's office is in charge of OLEG, Detective Klein asked the Attorney General's office to do an audit of Mr. Williamson's prior OLEG searches. That was done, and the Attorney General's office noted that there were a number of suspect searches done by Mr. Williamson. The Attorney General's office came back to the Sheriff's office and said, this needs to be investigated in a criminal investigation. You can do it or we can do it, but it's going to happen. So based on the Attorney General's requirement that there be a criminal investigation, the Summit County Sheriff's Office began the investigation. That investigation showed what ultimately turned out to be 36 self-searches. So Mr. Williamson searched himself on OLEG at least these 36 times. There were 10 counts that resulted from that. So about 5 months after he was indicted, another officer, a deputy who was Caucasian, was indicted for misusing OLEG. And that person was subsequently prosecuted and convicted. The trial court completely disregarded that fact. So Deputy Tackett, a Caucasian, was indicted, prosecuted, and convicted for misusing OLEG. So that backdrop is important because the burden of proof, and it's a heavy burden of proof that the defendant has to prove, which is 2 prongs of the test. The first test is basically that while other people who are similarly situated are being prosecuted, this defendant was singled out. And then you, in addition, have to show that the government's discriminatory selection for you to be prosecuted was based on bad faith, impermissible basis. Here they're alleging race. So as to that first prong, the appellee could not show that he was similarly situated to the 4 deputies that he argues about. So I'll get to all 4 of those. And noting again that Tackett is completely excluded by the trial court. And Mr. Williamson was not singled out because Tackett was prosecuted. So that's fatal to the first prong. But even before we get to the 2-prong test, there is issues with the trial court's journal entry finding that basically, Deputy Klein testified that there was no legitimate purpose for Williamson's self-searches. Mike Cody testified that there were no legitimate purposes for Mr. Williams' searches. That's pretty much ignored by the trial court. Also, in order to have a selective prosecution, the charging body has to have the discriminatory intent. And the trial court found in a footnote that the Summit County Prosecutor's Office, who was the charging body, had no discriminatory intent. So that's fatal to their cause as well. And it's important to note that the AG's office, the Attorney General's office, ordered an investigation. So there's nothing in the record at all to show that Sheriff Berry, who was the sheriff at the time, had any discriminatory intent based on race. In fact, the record shows that Steve Berry said, I'm staying out of this investigation because I don't want it to look like I am supporting in any way or doing anything favorable for this man that I actually respect. And he actually brought Antonio Williamson into the Internal Affairs Bureau to increase diversity. So
I have a question for you. Would the argument regarding what the court stated in its footnote and the charging body, was that argument made below during the hearing?
It was.
Okay.
Yes.
Thank
And
you.
our position all along has been that it was the prosecutor's office, not the sheriff's office, who made the decision to charge. And that decision to charge was based on an investigation that was required by the Attorney General's office, which is one of the ways that you can distinguish CP, GP, AB, and WW from Antonio Williamson, because the four of them did not have a required criminal investigation that was ordered by the Attorney General's office. In fact, the four of them had basically internal affairs looking at them for allegations of misuse of OLEG, and those things never got to a criminal investigation. And there's testimony in the record, and it's noted in the briefs with regard to the sheriff's department policy with regard to internal affairs reviews and then criminal investigations, and the two are separate. With regard to the internal affairs investigations, which would apply to these other four deputies, the sheriff is not involved until the point when that investigation is complete, and then they come back to the sheriff. That also makes those four deputies not similarly situated to Antonio Williamson, because he went the criminal investigation route, not the internal affairs route, and that was because the Attorney General required it. The journal entry also has a faulty conclusion that the only plausible explanation for why the sheriff would have failed to intervene in this criminal investigation, the only plausible reason would have to be race. Well, that's not the proper test, first of all, for whether there's discriminatory intent. And second of all, the only plausible reason why Sheriff Berry stayed out of this investigation is because it was ordered by the Attorney General's office. It was ordered, it was required. So he could not intervene in it. And it's clear that he wanted to stay out of it to avoid any appearance that he was favoring, not discriminating against, but favoring a deputy that he respected and had promoted into a position to increase diversity. Bless you. And the other error that's in the journal entry is that the court found that there was this multitude of OLEG violations by the Summit County Sheriff's Office. And that's incorrect too, because the only violation that the Attorney General found was that as part of training or a part of the performance reviews, the sheriff's supervisors would ask the deputy, go ahead, run yourself through OLEG, basically to see they have a valid license, etc. Once that was discovered, the sheriff's office stopped doing that. The Attorney General's office said that's a technical violation, not subject to discipline, not subject to prosecution. So CP is the only one of the four who even conducted a self-search. The other three conducted third-party searches, again, making them not similarly situated to Antonio Williamson. CP, however, ran a self-search at the request of his supervisor. The supervisor that was brought to the attention of the sheriff's office, they asked the Attorney General for an opinion. The Attorney General said, you're right, that is a technical violation. It's a training issue. The sheriff's office went through training of all the deputies after that. The AG's office did not recommend a criminal investigation, did not recommend any type of discipline for CP. And when you look at a violation of the Ohio Revised Code for misusing OLEG or leads, you have to show a knowing violation. So even if the Summit County Prosecutor's Office received a complaint for CP, it wouldn't have been filed as a criminal offense because he did not act knowingly. He acted under this order of his supervisor to conduct the self-search pursuant to completing his review. Again, not similarly situated to Antonio Williamson, who did 36 self-searches. Even if any one of them was for an annual review, it could not have been all 36. And again, Deputy Klein and Mike Cody testified they could find no reason, valid, legitimate law enforcement reason, why Antonio Williamson would have completed that number of self-searches. Again, completely rendering him not similarly situated to these other deputies.
I wanted to just double check on something. All the 4 comparables, well, actually the 5 with Mr. Tackett, were they all during the term of Sheriff Berry?
I believe, I have to go back and look. I believe one of them was not, and I'd have to go back in the record and see which one.
Is that the 5-year one or the Tackett one? Do you know?
I believe Tackett was during Sheriff Berry's time because that was indicted 5 months after Mr. Williamson.
Okay, thank you.
Yes. So with regard to AB, no self-searches there. He was off duty. He asked the dispatcher to run a license on someone that was following him. There was an internal investigation. Ultimately, they decided that that was a legitimate law enforcement purpose, even though he was off duty to run his search. That would not be a basis for a criminal offense because he did not knowingly violate OLEG. It was found to be an internally found to be a legitimate reason. Again, not ordered by the Attorney General's office. One search, not a self-search, not similarly situated to Antonio Williamson. WW also ran a third-party search. He believed that someone at one of his rental properties had felony warrants, and he asked for a lead search. So AB and WW were lead searches of third parties. That internal investigation came to a decision that that should have been a violation of OLEG, but the sheriff, when it went to him after that investigation, he said, no, I believe that's a legitimate law enforcement purpose. He had a call that there was, or someone told him that the person at the house had a felony warrant, and he checked that. So that's
Counsel, I just need to warn you, you're in your rebuttal time. Do you want to save that?
Fine. That's
Okay.
fine. I'll conclude and then I'll finish. But thank you, Your Honor. I appreciate that. So
right.
again, he's not similarly situated to Antonio Williamson because it was one search, it was a third-party search, and it was also a search that was found by the sheriff to be a legitimate reason. And then GP, which be the last of the 4, excluding Tackett, of course, he conducted a third-party search, and that was ultimately while they were doing the investigation internally, not a criminal investigation, also a reason why they're not similarly situated, he resigned. So the first prong fails. He was not similarly situated. It fails because he was not singled out because Mr. Tackett was prosecuted. The second prong, which requires discriminatory intent, that cannot be shown by some disparate treatment. The test is not, was this officer treated differently than another officer? The test is, was this officer treated differently? Was he similarly situated first? Was he singled out? And then was the treatment based on race? And here it wasn't based on race. He was prosecuted because there was an investigation that was ordered by the Attorney General's office. So based on the things that I've lined out as far as the errors in the trial court's journal entry, as well as the misapplication of the law, which this court should review de novo, the state respectfully asks that this court reverse the trial court's decision to dismiss these counts of the indictment.
Thank you. And for the appellee, you have 15 minutes.
Thank you. And again, good morning, Your Honors. I'm Ian Friedman on behalf of Antonio Williamson. Over my right shoulder is Mark Devan as well, who is co-counsel in this matter. Your Honors, I'd like to begin by stating it's an honor to be here on this most important matter. And while every case is important, this case really deals with an issue that can not any longer exist. It must be acknowledged and it must cease at once. And this case perfectly shows what happens when race is part of a decision. And what I'd like to do in addressing the appellant's counsel is just simply look to the language of the journal entry and then from the briefs. So if I may, the court in its footnote on page 9 stated that because the alleged OLEG violations typically are discovered with the Summit County Sheriff's Office, the court will analyze whether the Sheriff's Office is selecting individuals for criminal investigation and referred based on race rather than the prosecutor. There's been a lot of discussion as to the prosecutor having the right to charge and the Attorney General ordering an investigation. It misses the point for many reasons, which I will get to in a moment. The legal counsel, Michael Cody, for the sheriff's office testified that he would not expect Sheriff Berry to come right out and say that he did not like African Americans. The court shared also an agreement that it would be surprised if racial discrimination were ever openly admitted. And the facts here, Your Honor, suggest that there was, in fact, improper selection by way of improper conscious action against one and inaction against others. When we talk about the question of selective prosecution versus selective enforcement, and that really is what came up in the appellate's first brief, they state that the defendant asserts he was singled out by the Summit County Sheriff's Office for prosecution for allegedly violating Revised Code Section 2913.04 subsection D, while white male deputies who engaged in similar conduct were not referred for prosecution. That is accurate in this case. The court recognized properly in its footnote at page 2, this was never a question of the prosecutor's office and the way that they charged it. This was only the sheriff's office selectively referring this defendant while not referring others for prosecution, and it was in fact due to his race.
Counsel, let me just interrupt you because, you know, I know we've got so much to get through and I know you don't have much time, but I want to just zero in on something. And that is that this case did arise in a different manner than the other 4 cases you refer to as similarly situated individuals or comparables. In the respect that this started with a criminal investigation with the Akron Police Department asking for the Sheriff's Department to do things, and then the Attorney General's office as well. Whereas the other 4 were all internal, basically affairs type things that seemed to be really within the complete control of the Sheriff's Department. And was there any, I don't know this for sure, but it seems like no other evidence was presented that any third party was involved with the other 4 individuals. In other words, isn't that in and of itself different because the sheriff pretty much could not keep this quiet the way he did maybe with other people because there already were other law enforcement agencies involved?
So, Your Honor, that's a good question. There is no distinction still between the conduct. It is similarly situated between Mr. Williamson and the 4 others. It's important to understand that it was Deputy Klein at the direction of the Akron Police Department that began the investigation as to Oleg. He, as a tool in his investigation, referred the matter to the Ohio Attorney General's office, who confirmed that there were in fact self-searches. It then went back to the Attorney General's office did not say that you must prosecute this. What they said was you need to investigate this. No different than the investigation that was done by the sheriff's office for the 4 other similarly situated individuals. Once it was within the office of the sheriff's office, they made their determination as to the conduct of all 5, Williamson and the other 4. The only difference is that only one of them was referred. When we talk about similarly situated, the conduct here, the appellant in the briefs in here today again states that they are not similarly situated. I will address that in a moment. I hope that I have answered your question. Have I?
Well, I guess what my, I guess what keeps going through my mind is if this was not the basis of a criminal investigation to begin with, would the sheriff have treated him the same way?
Well, I think what's important to note is that as being part of a criminal investigation, one must look at the severance in this case. The state of Ohio stipulated to the severance in this case because it determined that one case had nothing to do with the other. While the state raises the point that there was a sexual assault investigation previously, the state did not even contest the severance because they said this was very different. Now, all 5 of those cases, and I'm not yet discussing Tackett, which is entirely dissimilar, all 5 of those were investigated by the sheriff's office. It does not matter how it got to the sheriff's office. What matters is, what did the sheriff do with it when it was realized that there were perceived violations of the OLEG statute or the lead statute, which for all intents and purposes is the same here, just different subsections within the revised code. What did the sheriff decide to do? So again, not how did it get here, but what did we do with it once we made that determination? So the terms of selective prosecution versus selective enforcement, frankly, and with all due respect, are distinctions in wording without a difference. The case law supports this, and the state of Ohio in its second brief at page 8 stated, quote, "The state is not arguing that a selective prosecution can never be based upon discriminatory conduct but by a law enforcement officer, but just not in this case." So the issue here that the state is missing is that the sheriff did in fact investigate this case. Again, however it got there. The sheriff referred this matter for prosecution. The sheriff justified and or overlooked other conduct without referrals to the prosecutor's office. And Judge Carr, you had talked about a moment ago in your question that this was not something the sheriff could keep quiet. If the sheriff was trying to treat all individuals within his jurisdiction equally, there would not be a question or any consideration of him trying to keep things quiet. If there truly was a belief that Antonio Williamson violated the law, then he should not have been trying to keep things quiet within his office. He had a duty, as law enforcement does, to refer this over to the prosecutor's office. One of the deputies in this case stated that in an investigation, a criminal investigation, it always goes over to the prosecutor's office. Well, in this case, the prosecutors in their brief state that, well, the circumstances in which it was being investigated within the office, one being administrative for disciplinary reasons, one being criminal, again, misses the point and is kind of a side issue. Because once it was known what the conduct was, do we really question for a moment whether the sheriff and those under him that were making the decisions didn't question whether or not it was, in fact, criminal conduct? Did they not really question whether or not their deputies could be prosecuted for this conduct? In fact, we see in this case that deputy is referred to as CP, although he recanted, originally took the Fifth. He knew perfectly well that the conduct could be prosecuted. He saw Antonio Williamson prosecuted. Did he come back and change that and say, yeah, okay, I did it and tell it? Sure, he did. But the point being, everybody knew that these folks could be referred just the way Antonio Williamson was. The only reason that they weren't is because of the decision not to refer it by the sheriff's office. Now, the standard of, I'm sorry.
Counsel, I'm
Go ahead.
sorry. Go ahead, Judge Callahan.
Well, Counsel, given what you just said, isn't it a fair statement that the difference in those cases, and I know you haven't talked about Tackett yet, I'm waiting for that, but the difference in those cases was the involvement of the AG's office with your client? Certainly that was a difference.
It is a difference, but I think as our brief points out, you do not have to have identical. You have to have similar. And when
Okay. I'll go with that. You're
Okay.
right. But hang on for a second, if I could. Would that difference then, it seems here, and I think maybe this is something that Judge Carr was alluding to or actually said, if the sheriff's office felt their hand was more forced because of the AG's office involvement with your client, would that have been a reason as opposed to his race? The
evidence in this case suggests that it was race, and for the reasons that I'll get to in a moment. But what the evidence does not show, Judge Callahan, is that this was because the Attorney General's pressure on the case. There is not one word of evidence to support that contention at all. The only evidence in this case and the complete picture, because the state says it was the AG that referred it for investigation. But if we read the transcript, we see that that's not the case. And if we hear the testimony from the hearing, it was Deputy Klein that began the investigation into Oleg to see whether or not there was an Oleg search on the date in question, which would have been March 17. He then referred it over to the AG's. Now, importantly, Judge Callahan, the AG's office sent it back and said, either you can investigate it or we can investigate it. But nowhere in this evidence, nowhere does it say that we will contest if you don't send it for prosecution. We will send it for a referral to the prosecutors. That never got there. And so all it says is you must.
I'm going to interrupt you too, because I know we don't have a lot of time, but I'm going to follow up with her question in regard to the AG's office. And thank you, Judge Callahan, because that's exactly what I was trying to ask Attorney Friedman, and that's what I was going to direct his attention to when we were asking the question at the same time. But at any rate, the forced hand type thing, you say that the Attorney General's office said you can investigate it or we can investigate it, but didn't the Attorney General, wasn't there evidence that the Attorney General actually said this is a violation, a criminal violation?
Just as the violations were determined yet allowed by the sheriff's office in the other 4 instances. These clearly were violations. And as we see, and I'll get into them now if it please the court, when we talk about the other 4, clearly I don't think anyone can state that there were not violations. We can minimize it by saying technical violations, but a violation is just that, a violation. Now, if we look at, as I work my way to tack it, and I'll be very clear on all of these, CP, number 1, was unable to articulate any legitimate law enforcement purpose for his self-search, yet the sheriff determined that there was no violation and no referral. It was very clear by the testimony of Deputies Klein and Deputies Plants. Klein at page 407, Plants at page 261, both stated that the number of searches do not matter and that there shall be no difference. Klein stated whether it's 1, 10, or 100. Plants stated 1 or 10. AB did a self-search. It led to no criminal referral. WW directed a dispatcher to run the leads on a renter of one of his properties, admitted to a violation of departmental policy, determined that there was no legitimate law enforcement purpose. It was recommended that he be terminated by the sheriff's own counsel. The sheriff then rejected that recommendation, even though it was determined that there was a clear violation, and this gets to your question, Judge Carr, of a violation of law. So when we say, didn't the Ohio Attorney General's office state that there was a violation of law? They asked to investigate that. Here, counsel for the sheriff stated that there was a clear violation of revised code section 2913.04, the same subsection for which Antonio Williamson was charged. And
that was counsel that worked for the sheriff.
That's right. That was Michael Cody.
And so again, there was no third parties involved in this, in these prior 4 cases. No Attorney General's office, no Akron Police Department.
Respectfully, again, I've got to just take issue, I suppose, with any consideration that that is the distinction that carries any sort of weight here. Because when we look at the conduct, that's what we're looking at, is the conduct of the offenders to determine whether or not they are similarly situated in their conduct. I am not familiar with any process that says how it got there or how it was received, but it's the conduct and whether or not it was referred. And so when we're talking about similarly situated here, the sheriff knew, at least was advised by his folks, that there was a violation and yet opted not to send it.
Counsel, you have just about 30 seconds.
Oh, is that it? I'm sorry.
Yep. No, that's fine.
All right, very good. So I'll just get to Tackett, since that has been one of the questions that has been asked here. And Tackett very clearly has a number of issues. Number one, he was indicted after Antonio Williamson. The equal protection violation had already occurred, period. One could suggest the state had to charge. I don't think we even need to speculate here because the violation had occurred. Most importantly, and what makes Tackett completely different than all 5 of these instances, and the reason that the court didn't even feel it necessary to include it, was that that conduct in that case by that deputy was the basis for the substantive counts. This was a stalking and a menacing case, and the underlying conduct was done by way of the use of the OLEG to determine the locations of the sheriff's dispatcher, who he was having a romantic relationship with, to search the identities and the locations of dancers who owed him money. And so in order to make the substantive case, you had to identify the OLEG. So for those two reasons,
thank you, counsel.
very different. I thank you, the entire panel and counsel as well for the state.
Okay. And counsel for the state, you have just about 2 minutes left.
Thank you, Your Honors. I just wanted to summarize by saying that race is not part of the decision. The record clearly shows on page 459 that the Attorney General's office required that there be an investigation. On page 479 of the transcript, it shows that once there is a criminal investigation completed, it must go to the Summit County Prosecutor's Office. This case was different than CP, GP, AW, and WW because there was no criminal investigation, which then required to go to the prosecutor's office, who ultimately made the charging decision. That makes them different. Also,
Are you, I'm sorry for interrupting, are you indicating that the Sheriff's Department did not make any recommendation that this was a violation of?
they did not.
They just presented what facts they had learned?
They found the facts, which were the 36 self-searches, which was why the Attorney General's office referred it to begin with. You are not allowed to do a self-search. There's no plausible reason for it. And I completely disagree with Mr. Freeman when he says that CP did not have a good faith basis for a search. He absolutely did. He did it at the request of his supervisor. And again, if that had come to us as a case to prosecute, we would not be able to show that he knowingly violated the OLEG statute because he did it at his supervisor's request. So these 4 do not meet the burden for a criminal prosecution. These 4 are also not proper comparables, as Judge Carr and Judge Callahan pointed out, because they do not involve a third party. And under Lamar—
Well, let me just clarify. We didn't point out they weren't comparable.
No, you pointed out that
asked
they were
questions
right
in regard to it. Okay, I'm just making sure we're on the same page.
that conclusion, but that you pointed it out. And it's important because if there's a meaningful distinction that explains the difference in treatment, then that makes them not similarly situated. And that's under Lamar. And we have to look at all the relevant facts and circumstances. I understand that Mr. Freeman wants the court to only look at the fact that Mr. Williamson was Black and these 4 were white and Mr. Tackett has some other difference. But Mr. Tackett was more like Williamson than any of the other 4, also because his OLEG violations came about during the investigation of the underlying crime. So for the reasons that I articulated in my brief and that I argued here today, the trial court erred in finding that the first prong of the prosecutorial selective prosecution was found. These folks were not similarly situated. Mr. Williamson was not singled out, and there is no evidence that there was any discriminatory intent by the Summit County Sheriff's Office, the Summit County Prosecutor's Office, or the Attorney General in prosecuting Mr. Williamson for these 36 violations of the OLEG statute.
Thank you, counsel. Thank you. I wanted to thank you both for your presentations, and the court will take the matter under advisement and will issue a written opinion that will be sent to both sides, as well as the fact that we release electronically on the website for the Supreme Court and our site. So thank you again, and I hope you get to enjoy the rest of your days. Thank you.
You as well.